Generally, when it relates to the EEOC and dealing with the EEOC's process, and it is a very distinct process that must be followed, and it's important that the process is followed because once the matter is filed in court, a part of the or I should say one of the reasons a case could be dismissed is if all of the administrative proceedings, which the EEOC qualifies as a part of, have not been adhered to. And so the understanding the EEOC process is critical. A lot of lawyers that are not experienced in that area don't understand the EEO process. We're kind of fortunate here at Smith and Green that our managing partners were former EEOC investigators. So this is the world that we lived in for some time, understanding the process. Virtually what happens with the EEOC is once you've voiced your concerns with the employer, and again, that's a separate topic of conversation, and you feel like it has not been resolved amicably, or it was a termination where you no longer have the right to voice it with the employee, or the employer, I should say, you file a claim with the EEOC. That could be done either by walk-in or online. You schedule an interview with an investigator. At that time is when you lay out your concerns as to why you feel you have been discriminated against based on one of those 5 laws. It's important to note that some of the claims have a 300-day statute of limitation on them. Others of the claims have a 180-day statute of limitation on them, which literally means you must have that claim filed with the EEOC, or it's we call it a fair agency practice agency, which is a state agency that's charged to collect those types of claims or address those claims. In Arizona, it happens to be the Arizona Department of Justice handles those claims, their employment division. Depending on where you file it, could also have impact on whether it needs to be filed within 300 days or 180 days. Not all employers qualify under the statutes of the EEOC. For example, under Title VII, if you're going to file a race discrimination claim, you feel like you're being treated differently than people who are of a different race than you, or a different sex than you, or a different religion than you, or a different skin color than you. That employee or employer has to have at least 15 employees. That's the broad rule. At least 15 employees to qualify or to be subject to the rules or the requirements of Title VII. If that employer only has 6 employees, they wouldn't qualify under Title VII. Now, there may be some other local, as in municipal codes that could hold that employer accountable, or state codes that could hold that employer accountable. But under the federal statute, Title VII, you would have to have 15 employees. That's not a hard line rule, because if you could have 15 employees over the course of a specific period of time, over a year, for example, that could qualify, could meet the 15 employee threshold. If the employer only has 1 employee and has only had 1 employee for an entire year, Title VII is not going to be your statute of choice to pursue under. So that's just an example of how the EEOC works. They would look at this to make sure that that employer is actually subject to the law of Title VII or some of the other laws. So virtually you would go down to the EEOC, schedule it over the phone, or you can do phone interview, you can do fill out the forms online, or you can come to a lawyer's office that has all the information. They would draft up a charge for you, referred to as a Form 5. That is the charge of discrimination. It is a plain and simple statement of what has happened to you, how you feel like you were discriminated against, what was the difference in treatment or the impact of the difference in treatment, and then that once that charge is filed with the EEOC, the tolling time stops at that time. In other words, time is tolled at that point. Your statute of limitation, virtually, if you're within that 300 or 180 days, it's suspended. So, and some of these cases go on for years and years, but it's suspended at that point. You're safe. At some point, you'll be able to file it in court once you receive a notice of right to sue from the EEOC. At that point, the EEOC generally has about 10 days to make sure that that claim is served on the employer. In other words, the employer gets notice of the claim. And if that investigator determines that the claim has merit to it, then that employer will be required to submit a response, or what the EEOC refers to as a position statement or a statement of position. It's literally them explaining their side of the story. A lot of times, especially with bigger employers, they will hire outside counsel. Some of them have inside counsel. Some of them let human resources respond to these claims. And this information is submitted to the investigator and the investigative staff at the EEOC to either conduct interviews, analyze the evidence submitted by both parties. They can conduct fact-finding conferences where they bring the parties together, kind of sort out the facts, and then that yields their determination. They can interview managers. They can interview your witnesses. And a list of things. They can request information from the employer, like records and different things pursuant to the Freedom of Information Act. There are several tools that they have because, again, they are an investigative agency that's charged by the federal government, or if it's the Department of Justice here in Arizona, they're charged by the state to investigate these claims. And so prior to investigation, there's something that could happen, which is called mediation. The case is referred up to mediation depending on how it is. Not all cases qualify for mediation, but some cases do qualify for mediation. This is where the case goes to another division of the EEOC, the non-investigative division, the alternative dispute resolution, if you will, division of the EEOC, and they try to resolve those claims. They bring the two sides together with a mediator, an EEOC mediator. Some EEOC offices have contract mediators they bring in to sit down with the parties to try to mediate those claims. If a resolution is met in mediation, then the parties are bound by it. The EEOC can enforce the mediation agreement. And oftentimes this is preferred because litigating these employment law cases could be quite lengthy and could be quite expensive, and it's kind of oftentimes it's like David versus Goliath. You have this big company who has deep pockets, if you will, and this employer who has legitimately been treated differently or has legitimate concerns, but oftentimes they can outlast you. So mediation is always something that all the parties, I recommend employees and employers to look into, because it's a chance for you to resolve the issue. Nobody really leaves the mediation feeling like they necessarily won, but again, it's that middle of the road, it's the meeting of the minds. If the case is unsuccessful in mediation, then it pursues in the investigative track. Right now, currently, the EEOC, and oftentimes they get behind because of staffing issues and whatnot. So it could take a case a couple of years to resolve or to get to some type of conclusion. But at the conclusion of that case, the EEOC investigator or the director of that particular office will sign off on a decision. They will determine that there was a cause finding that the law was violated, or there was a no cause finding. In either case, they can issue you a notice of right to sue. If they have a cause finding, then they take the case into conciliation, what they call conciliation. And again, it's similar to mediation, but once the EEOC determines that the law has been violated, for lack of better words, at that point is when they lose their neutrality, if you will. Throughout the entire process, remember, they are a third-party neutral agency. They're not for you. They're not for the employer. They're just gathering the facts and making a determination. Again, they are a third-party neutral agency. That is the big misconception with most employees. I'm going down to the EEOC, then they're going to fix it. Well, that's not true. They're a third-party neutral agency. They will look into it, but it's not until they find that the law has been violated where they, again, for lack of better words, lose their neutrality or shed their neutrality, and then they tell the employer, we believe that you have broken the law in this case. We want you to come to conciliation with us and try to resolve that. And again, there are caps and statutory requirements to things that they can ask for, things that they can't ask for. It's all controlled by the law. If conciliation is successful, then the charge of discrimination is resolved. No lawsuit is filed. If the conciliation is unsuccessful, then the EEOC can opt to sue the employer on the employee's behalf, which those are the great minority of cases, 9 times out of 10, that does not happen unless there is a class of people or it's some specific segment, element of law that needs to be more defined. Then the EEOC will have some of its attorneys pursue on behalf of that employee if it's egregious. And I've seen several occasions where defined attorneys over at the EEOC will pursue a matter for the employee. If they're not able to resolve it in conciliation, then the EEOC will issue that notice of right to sue and the cause finding to the employee, instruct the employee that they have 90 days to file the matter in court, and they have a finding from the EEOC that the EEOC believes that the employer has broken the law. At that point is when most, which I don't recommend that, but this is the point where most folks go looking for a lawyer and say, hey, I got 90 days to file this in court. It's beneficial. I said all of that to say it's beneficial to have a lawyer early in the process, so that especially lawyers who are experienced with dealing with the EEOC. Many attorneys will turn you away. Well, let's see what the EEOC says, because it's free lunch virtually. But again, one of the benefits of our law firm is we were EEOC investigators. We know the process. We know what needs to be done. We know what loopholes to look for, and to make sure, almost an EEOC watchdog, to make sure that they're doing their job, and know when to pull a case, when to file it, and how to walk the case through the administrative process so that your rights are preserved and that you have a better chance should the matter be filed in court. And so that's a little more information about the EEOC and its process.